major role in making sure that these statutes are carried out. Where did the citizen suit come from?
Well, it's an interesting story. Ed Muskie's best and closest friend in the Senate was Senator Philip Hart of Michigan, a equally liberal Democrat, who introduced legislation to provide for class action environmental suits, which essentially would have authorized the courts to resolve environmental disputes and set environmental standards. It was a product of a Joseph Sachs professor at the University of Michigan Law School. Muskie loved Phil Hart. He hated the idea of turning environmental decision-making over to the judiciary. And he told Tom and me, I've got to figure out a way to save face for Phil Hart, but I will not have class action suits in the Clean Air Act. So Tom took on the task of finding an alternative. And I will say that while we had some really good advice from Senator Birchby and Senator Tom Eagleton, it was largely Tom's product, Tom's creativity, and Tom's belief in the concept of private attorneys general.
Now, what the purpose of the citizen suits became was a way of doing two things. One is to allow the citizens to gain access to the enforcement process. We had already had experience with earlier laws that requirements that were to be met by the regulated parties were being violated, but there was no enforcement for a number of reasons: lack of staff, lack of budgets, whatever. Sometimes good reasons, sometimes not so good reasons. So what's a way of addressing that when the administration, state or federal, don't enforce the law? What's the recourse? How do you get that enforcement matter in front of a court? Judiciary is ultimately where enforcement is going to occur. So the first piece of the citizen suit was to couple the changes that were made in the statute so that the enforcement went to emission limitations, specific obligations of parties to meet a certain performance. That was the subject of enforcement. If the feds or the states didn't enforce, to give the citizens an opportunity to bring those suits. So it was an enforcement mechanism. The second piece was another product of the learnings of the earlier statute. If the Congress tells or grants authority to the executive branch to do something, to publish a regulation, to monitor this or that, and that agency, again, for any number of reasons, chooses not to, what's the recourse? You can say oversight of Congress. Well, that's a weak tool. So the second element of the citizen suit that was again coupled to changes in the statute, which is to change the granting of authority to the executive from discretionary authority, characterized by the word may do this or may do that, to the word shall, and accompany that mandatory characteristic of those duties with a deadline to perform them. And again, you can write that mandate with a deadline into the statute, but if the executive doesn't comply, what's the recourse? Again, there isn't really good and adequate recourse. So the second element was to give the citizen the opportunity to go to the federal courts and say, the agency has failed to perform a mandatory duty under the Act. And that has had tremendous effect in compelling products to be delivered by, mostly in this case, EPA. So those were the two elements that fit the other changes that were made in the statute, and as we've described it in class, getting from an objective, public health, national ambient air quality standards as the objective, to actually getting a pound of pollution out of the system at the end of the administrative process, the judicial review process, and the implementation process, to give the citizens a final way of forcing that long chain of activities to be accomplished. So those were the two elements that we were able to persuade, in this case, both the committee, but also Senator Hart, gave the citizen a real and meaningful voice in the implementation of the laws.
So the first of the major statutes of the modern era, environmental statutes, was the National Environmental Policy Act, which President Nixon signed on January 1, 1970. And it launched the era of the environmental impact statement. Where did the environmental impact statement come from?
Well, there are probably two ways to tell that story, but I don't think we have time for the whole story. The Senate, in violation of its own unwritten rules, passed the National Environmental Policy Act on the consent calendar, even though Senator Muskie had a hold on that legislation. In my experience, my dozen years on the Hill and since, I have never seen a hold ignored and a piece of legislation passed when the hold existed. Needless to say, Senator Muskie, who I think you've learned from what I've had to say, was not a man of quiet response to negative events, took umbrage at the situation, and he blocked the National Environmental Policy Act from going to conference for quite some time. Finally, Senator Mansfield, who Muskie liked very much, admired, called Muskie and Senator Jackson, the sponsor of the National Environmental Policy Act, into the cloakroom and said, "Boys, you're embarrassing the Senate of the United States. Resolve this." And so one of the problems was that Senator Muskie didn't like Senator Jackson. They were deeply divided on the Vietnam War. There were years of various, I guess you'd call them insults, traded back and forth. So he refused to talk to Jackson. So I ended up being the Henry Kissinger of NEPA, going back and forth. Scoop and I got along fine, and Senator Jackson's nickname was Scoop. He had been a reporter. I took pieces of paper from Muskie to Jackson to, well, first to Jackson's staff, but they rejected all these proposals, and finally I ended up negotiating directly with Jackson. One of the National Environmental Policy Act, as reported and passed through the Senate, as Jackson wrote it, created something called a finding, which would essentially, in Muskie's view, allow a federal agency, primarily an extractive agency, mission agency, to issue a finding justifying their environmental action. Muskie thought that this was totally antithetical to his objectives. Excuse me. And so he said, what I want is I want to substitute finding with the term detailed environmental impact statement. And I want this statute to include a requirement that the federal agency conducting the study, environmental impact study, examine the alternatives to the proposed action. And then I want the document to be subject to the review of all federal, state, and local environmental agencies before it is finalized. Eventually, Jackson, in order to get his conferees appointed, agreed not only to take those amendments to conference, but to not bring a bill back from conference without those provisions. So Jackson took it over to a congressman who had a temperament very similar to Muskie's, named John Dingell, and after the smoke cleared, Dingell accepted those amendments, and that's how we got NEPA as it is today.
I would just add to that, there was a very distinct difference in legislative philosophy between Senator Jackson and the Interior Committee, which is what Jackson chaired, and the Public Works Committee and the Subcommittee on Air and Water Pollution, which Senator Muskie chaired. And the basic philosophical difference was Jackson had the view that all you had to do is tell the agencies to be good guys, and they would be good guys. What Muskie had learned by that time is agencies can't be exhorted to be good guys. They had to have specific directives, and those directives had to be able to be enforced and to be held accountable. And so that philosophical difference is what led Senator Muskie to this idea that a finding by the Corps of Engineers that their dam is going to be okay with respect to environmental impact is not a vehicle that that is destined to produce much change in that agency's performance. The only way was to have a detailed statement, but it was even more than that. If you look at the Clean Air Act and the Clean Water Act, there are opportunities for public participation from the time you start rulemaking all the way through to citizen suits. And what Senator Muskie believed was that if there was a detailed statement, then that agency was going to have to make it public, and the public were going to have an opportunity to review it, because that would be the accountability mechanism for the performance of those agencies in changing their environmental behavior. There was one other element that I'll just touch on because I see the clock is running, and that is there is an issue in NEPA that concerned us greatly, and that was NEPA basically says every federal agency, and what especially articulated by Senator Muskie was you can't use the NEPA, which is in many respects a benefit cost kind of test, to override into the clean air or clean water regulations with NEPA obligations. You couldn't use NEPA to weaken the statutory requirements that the Clean Air and the Clean Water Act. This became known as the NEPA-EPA issue, and it was, we thought, resolved in the statute. We found that some courts ruled against us, but finally it's been pretty much addressed that you cannot use NEPA to weaken a environmental requirement from the Clean Air Act or the Clean Water Act. So
the interesting thing is that this issue was brought to our attention by a lawyer with Hunton and Williams, which was that was Lewis Powell's law firm, and if you remember Supreme Court Justice Lewis Powell, who had been the chief counsel to the Chamber of Commerce, who was largely responsible for the Southern strategy in many respects. George was representing the electric utility industry, and he came to us and he said, you know, we can use NEPA against all of the provisions of the Clean Air Act and the Clean Water Act. And you know, I have the great benefit of not being a lawyer, and it immediately occurred to me that that was a political problem. Fortunately, it also occurred to Tom that it was a serious legal problem. So we took it to Muskie, and he saw it immediately, and that's why there were provisions put in both the Clean Water Act and the Clean Air Act to make sure that NEPA didn't frustrate the objectives of those laws.
Since we started a little late, we'll go a little later than we had planned. And so I have one more question I want to ask you, and then we'll open it up. In 1970, when you wrote the Clean Air Act, no one was thinking about climate change. But since Congress has failed to take any action on climate change, EPA today has to rely on the Clean Air Act of 1970 and the 77 and 90 amendments to deal with that issue. The biggest source today of greenhouse gas emissions in the United States is the existing fleet of coal-fired power plants. The major legal tool in the Clean Air Act for that is Section 111, but it makes it allows EPA to regulate proposed new plants directly, but for existing facilities, it's a very narrow provision, and it requires EPA to give guidelines to the states, and the states then have to act. How did that come about?
Well, it's an interesting history. One of the toughest things, and we talked to the class about this, is in writing legislation, you want to anticipate things that you don't know about at the time you're writing the statute. So
You say we wanted to anticipate. That's not necessarily what everybody else does.
That's right. And so there was a provision in the Senate-passed bill. It had a very inartful title, Section 114, and it was called Selected Pollution Agents. And it was basically a parallel provision to Section 111, which is what Mike has described as the new source performance standard, but was an authorization for EPA to address air pollutants that would come along in our understanding as the continued evolution of understanding and monitoring technology and health effects and the like. So selected pollution agents was written to do that, and it's a parallel provision to Section 111. When we got to the House, in the conference, we had a very tight deadline. We were acting in September to pass the Senate bill, and that Congress would end in December, and the slate would be washed clean if we didn't complete action. So a very hectic conference period. And the House suggested, well, since that provision is so close to Section 111, why don't we just weave the addressing of unknown pollutants into subsection, what became subsection D of Section 111. So it came out of that. Now, I can tell you that when we listed in the Senate report the types of pollutants we thought were going to be first addressed by that provision, CO2 was not among them. Boron, and I can't remember
Cadmium and
a whole series of compounds that we didn't have enough knowledge to write a specific standard about. Now, the question also is an admission. At the time we were writing that statute, you measured good performance by how much CO2 was being emitted. If you think of a hydrocarbon molecule, HCO, and you combust it, perfect combustion is to generate water and carbon dioxide. If you were generating other stuff, that was meaning you weren't burning that hydrocarbon molecule completely. So in a sense, at that time, CO2 was looked on as a measure of clean performance. But the way the statute is written, if you can establish that CO2 is a pollutant, then Section 111D gives you the authority to write emission limitations for it.
And the Supreme Court decided that CO2 was a pollutant, and so I very, very much doubt that there are many people who are even aware of this Senate provision on selected pollution agents. It was discussed in the Senate report. It was not discussed in the debate on the conference report. It was not discussed in the conference report. It's simply, we were sitting around at 4 o'clock in the morning. What Tom didn't mention was we passed the bill in September. We had one conference with the House. Members went home for election, didn't come back until the middle of November, and we sent this bill to the President on December 18th. Isn't that right?
Yes.
So we were this was a complex piece of legislation. It was only 38 pages long, but it was a complex piece of legislation. And the House Counsel suggested that one way we could keep the concept of selected pollutants in there without having to go back to the members and go into an extensive discussion of regulating pollutants that we didn't even know existed, would be to incorporate this provision in section 511, and that's how it came about. It was, you know, it was one of the few times that I can recall that that a provision, the Senate members knew that provision was in the bill. I don't think the House members had the slightest idea. I don't think the House members had the slightest idea about most of the bill in this particular case. But in this, because we were so late, we essentially put that in as a staff agreement, and the members signed off on it.
And that provision is now the most important provision in the Clean Air Act for fighting greenhouse gas emissions. So let's take some questions, and I think there's some people with microphones who will bring.
Yeah, there's two on either side of the room, so raise your hand and. All right, Mr. Warren.
No, wait a minute. Wait, can you get the mic?
And incidentally, as way of preface, Chuck Warren at this time was working as a legislative assistant to Senator Jacob Javits. So he's got an inside perspective.
You talked about some of the things in that time that led to this outpouring, the golden age, and I think that's right, but wasn't there also a time of public awareness and public support? You had Earth Day in 1970, you had a tremendous amount of public support for all that, which, you know, which we don't quite see now that we're dealing with more sophisticated kinds of environmental issues. I mean, we still have clean air and clean water, but you're dealing with climate change, as Mike was talking about, and that's something that, well, people can think about. They don't really, it's not really as immediate to them. And do you think we might see a resurgence of that kind of feeling that will then move the legislature and the agencies a little more in an environmental direction?
That's true. Some of you may be old enough to remember Walter Cronkite, who every night ended his nightly news show with a pollution story for months, which was, you know, showing rivers on fire in Ohio and dead fish on the banks of Lake Erie and needles flowing up on the New Jersey coast. I mean, there was so much visible video evidence of the scope of the air, water, and solid waste pollution problem that once TV started covering it, there was a significant growth as well. To the point, I want to make one earlier point. In the 12 years that I worked with staff director of the subcommittee, we had one party line vote. And that was over how much money to provide and the method of providing money for wastewater treatment plants, the so-called. Anyway, and I only make that point because if anything underscores the points Tom was making about how we work together, it was 12 years of absence of party line votes. We had serious disputes. We had 5-4 votes. We'd have the two coal company business Democrats voting with a couple of the more conservative Republicans. But we had this coalition of By, Eagleton, Montoya, Muskie, Baker, Boggs, and Cooper, who mostly stuck together. But that's enough.
And the Clean Air Act of 1970 was passed virtually unanimously.
It was unanimous. It was, well, there were two members who paired their vote, yeah.
One of the things we were debating, and Josh may be able to get us a photograph, but we were thinking as a backdrop to our class, we'd have a picture of the air that Steve has just been describing he experienced in Beijing, and we'd have a picture of Beijing and we'd say, there but for the Clean Air Act goes New York. We were on a very bad trend in 1970, both in air and water. And it was those two statutes that not only took that trend and reversed it, but now, even with the tremendous expansion of population, vehicle miles traveled, number of cars, there's 78% less pollution than there was in 1970.
I want to mention one other thing. You mentioned the Oil Pollution Act of 1990 and the Clean Air Act amendments of 1990. In a way, the same circumstances existed for a very brief time. George Mitchell, who was the Muskie's successor, senator from Maine, and the chairman of the Environment Subcommittee, and John Chafee of Rhode Island, a very green Republican, would have been a little bit more conservative than Jake Javits, but not a whole lot, and a guy named George H.W. Bush. George H.W. Bush was a green Republican. He wanted this Clean Air Act, and because of Mitchell's ability to work with George H.W. Bush, much the way that Muskie worked with Howard Baker, that bill and the oil pollution legislation was passed. So it was, again, an example of what happens when you can put the partisan issues aside and bring together these competing political forces.
Keep your hand up so they see the microphone gets to you.
Thank you. My first question goes that how, like it was defined in 70s and now it's like already 2020 we are heading to. So what should be the thing which could ignite the modification of these laws again? And secondly, it goes in like, at what point of time you incorporate real scientists into the formulation of these acts? Because I feel that everybody is not expert in everything. So how and when either it's done or how it should be done, could you throw some light on that? Thank you.
Well, you raised the question about the role of science. And one of the things that's an outcome of the work that was done in the 70s, they were based on science, good government science on the health effects of air pollution. And the message that was taken from some in the private sector from that was, the only way to stop this is to attack science. And so you have now a situation in which huge resources are being expended by folks attacking the science. And that is a message that emerged out of the successes of the 70s. And it's a sad message because it displays a kind of attitude towards the American people that is quite negative. If you look at that period and sort of put it as a quantum of science that supported the Clean Air Act, it was, let's say, 100 units of stuff, good science. If you put climate change up against that, it's 1,000. And yet, with that amount of science, it's still being discredited by a combination of the media's desire to take one person from this side against 1,000 people from this side and equate them. So you always see articles that there's this group of scientists that support the notion that it's human-caused climate change and those that don't, as if it's up for grabs. Well, it's not up for grabs. But the role of science is under attack. Now, that's also under attack. We talked about this in class today. If you ask a Republican, almost any Republican now, not the kind that I served, about climate change, who nominates what their answer is? Not the folks in the class. They already know. Huh? What is it? Well, about scientists, but what do they associate with climate change? Two words.
Go ahead.
They say job killer. Anything dealing with climate is a job killer. So that's not an appeal to science, it's not appeal to rationality, it's appeal to emotion. And that is proving to be very effective in terms of sort of putting up barriers between problem solving and continuing the status quo.
In answer to your first question, number one, we have been on the defensive for 20 years. with that exception, that window when George H.W. Bush pushed for the acid rain legislation, which got the 1990 Clean Air Act amendments, and the oil pollution legislation in 1990. With the exception of those two provisions, we have been on the defensive. We had to fight Ronald Reagan and his team of conservatives all the way through the 80s in their efforts to gut the Clean Air Act. And we've had to fight the Republican-controlled House of Representatives. When the Republicans took control of the House in 1995, they had a document that I call Contract on America. I think it was called actually Contract for America, something like that. And that document was filled with buzz phrases that became the mantra of the GOP in the House of Representatives. Sound science, regulatory reform, these kinds of terms. And so through all that era, we've been on the defense. We've not been on the offensive. And one of the problems that we discussed somewhat today in class is that we advocates don't have the kind of message units that the opponents have. They invest tens of millions of dollars in developing these messages, you know, like death panels in relation to health care. They spend tens of millions of dollars developing these messages, and unfortunately, my party wants to have an intellectual discussion. It's like, my wife would say, carrying a knife to a gunfight, and until we start using a gun, we're not going to see any progress.
Why don't we take one more question?
We've been talking about U.S. environmental laws, but in a global economy, how effective is environmental law when U.S. companies can easily move their manufacturing overseas, where the laws are much more relaxed and they can pollute even more? Is there an international solution to that, or is there anything that we can do?
Having served with an international company, your question is very, very appropriate. In many respects, many countries followed the U.S. with